Ready? Start. Admittedly, petitioner number 1 is husband, whereas rest Patna High Court Sia miscellaneous number 45894 of 2013 3 date 1/11/2013 petitioners are in law of opposite party number 2. The opposite party number 2 filed complaint case bearing complaint case number 589 of 1998 against the petitioners and two others, namely Kumkum Devi and Laddu Singh, who died during pendency of aforesaid case. After inquiry, case was prima facie found and accordingly petitioners were summoned to face trial. Petitioner number 2, 3, 5, 6 and 7 were granted privilege of anticipatory bail by the learned sessions judge passing different orders, and in pursuant to the aforesaid orders petitioner number 7 appeared before the trial court, but rest petitioners did not choose to appear before the court. Similarly, petitioners number 1 and 4 did not make their personal appearance before the court, rather filed a petition under section 205 of the CRPC, which was rejected by the impugned order. In all appeals under the letters patent, a duly stamped memorandum of appeal shall be presented to the registrar within 60 days and not more from the date of the judgment, unless a judge in his discretion on good cause shown shall grant further time for its presentation. The memorandum of appeal need not be accompanied by a copy of the judgment or decree appealed from. A full bench presided over by Sir Robert Stott, CJ, held without stating its reasons that under the rules of practice adopted in 1873, which provided that the appellant need not file a copy of the judgment appealed from, an appeal under clause 10 letters patent, which had been preferred 2 days after the period of limitation had expired, could not be admitted. That decision is directly in point, and the question is whether it is still good law. Shri Eki Kirti for the appellant has advanced two arguments on behalf of the appellant. His first contention is that the rules made by this court under the letters patent constitute a special or local law within the meaning of section 29 to Limitation Act 1908, and that accordingly the provisions of section 2 of that act will apply for the purpose of determining the period of limitation. In the alternative, he contends that the provisions of section 12 Limitation Act apply to appeals under the letters patent. Section 29(2) as it now stands provides that where any special or local law prescribes for any suit, appeal or application a period of limitation different from the period prescribed, therefore, by the first schedule, the provisions of section 3 shall apply as if such period were prescribed, therefore, in that schedule and for the purpose of special or local law. The provisions contained in and for sections 9 to 18 and section 22 shall apply only in so far as and to the extent to which they are not expressly excluded by such special or local law, and the remaining provisions of this act shall not apply. It is not in dispute that the first schedule to the Limitation Act does not provide a period of limitation for an appeal under the latter patent. That late Sri Joginder Singh had also left behind 3 daughters, but since the properties were co-parenting and plaintiff being one of the co-partners here, the daughters have no right in the said property and as such are not being made a party to the suit. The legal position with regard to intestate succession under Hindu law is well established. Prior to the coming into force of the Hindu Succession Act 1956, the moment a son was born, he acquired a share in the father's property and became part of the co-parency. The property of the father became part of the joint Hindu family of his son and grandson and other members who formed the joint Hindu family. This position was radically altered by the coming into force of the Hindu Succession Act 1956. Section 8 of the said Act lays down the general rules of succession in the case of a male Hindu dying intestate. In view of the preamble to the Act, that is, that to modify where necessary and to codify the law, in our opinion, it is not possible when schedule indicates heirs in class 1 and only includes son and does not include son but does include son of a predeceased son, to say that when son inherits the property in the situation contemplated by section 8, he takes it as karta of his own undivided family. Source is 3P Legal RHC and exercise number is 49. Words are 760 and speed is 100.